Good morning, everybody, and welcome again to another online webinar of the National Institute for Occupational Health, the NIH. The NIH is a specialized division of the National Health Laboratory Services, the NHLS, sister institute to the NICD, the National Institute for Communicable Diseases. Today's topic of our webinar is medical incapacity related to COVID-19. It is part of the NEDLAC NIH COVID-19 legacy program that commenced about, I think, more than a year ago, almost a year and a half ago. And on today's topic, we have Attorney Peter Strassheim, and you've seen his bio in the pre-webinar slides. I'm not going to get into any details there. And in particular, he will be addressing the issue of incapacity secondary to COVID-19, what are to look out for. I hope I've just used the correct title. I think it might have changed. So let me just double check. Oh, here we go. Medical incapacity related to COVID-19, a brief overview of selected key aspects of the applicable law and relevant employee benefits. I'm going to immediately ask my colleagues in the IT department just to share the slides. And while that is happening, I'm going to ask Peter to open his microphone and his video, and then I will be able to hand over to him immediately. And whilst that is starting, we are inviting you as attendees to please type any questions you have only in the Q&A box. That is the Q&A box at the bottom. It has got the double speech bubble at the bottom, and any other general admin or non-Q&A or question related things you can do in the chat box itself. That's fine. We also will be having we have quite a very intense or detailed presentation and contribution today from Peter Strassheim. And so it's important just to not just welcome you, but to kindly request you to do those questions in the relevant Q&A box, which will be answered accordingly. And if there's any questions that's not dealt with there, we will ask you to ensure that you send anything unrelated to this topic or anything unrelated to the presentation slides of Mr. Strassheim to our info@nih.ac.za email address, right? We also encourage you to go have a look at our NIH website for any other topics we might have dealt with before, and the NIH YouTube channel. And I will be putting those in the chat box, the links to our website and to our YouTube channel, to look at the other topics we've covered before, which is unrelated to this particular topic and presentation today. And if you still need to obviously put something to us, please use the info@nih.ac.za, info@nih.ac.za. Use that email box and send the questions to us. And without further delay, I'm going to immediately hand over to our guest, Peter Strassheim, and you see that his slides are on the screen, and we will proceed with the first, your introduction, Peter. Thank you very much for taking the time to prepare and to avail yourself for this webinar. Much appreciated. Handing over to you, Peter.
Many thanks. Much appreciated, Ashraf. And thank you for inviting me. I'm greatly privileged to participate and share what knowledge I have with everybody. The devastation of COVID-19 had major impacts for just about everybody. For medical practitioners in realizing what could be done to assist their patients, for employers in understanding the impacts of incapacity and disability in the workplace and the need to manage it, for employees who needed the information to protect and promote their interests, recover and get better, for trade unions. I would imagine for NEDLAC to reflect upon the current state of the law, also for the Ministry of Labour and Employment to do much the same. And that's really the context for my presentation. It's really about, yes, COVID and its sequelae for employees with long COVID, as it's called, but in the context of employment law and labor law. Now, as I begin, remember please that this is the least understood field of labor law. It's least understood because there's so few of them. If you add dismissal disputes and retrenchment disputes, disability incapacity disputes are only about 5% of all of the CCMA cases that come in. The result is that they're largely unknown simply because people are unfamiliar with them. But COVID changed all that. There's a new scrutiny on disability law, incapacity law, and also whether the law as it stands now is adequate to deal with the challenge that medical practitioners, patients, and employers have. So that's the context. I've been asked, the topic of my presentation is really, as Ashraf says, a brief overlook of selected key aspects. It's a broad, complex field, but these slides are deliberately detailed so that you have a ready reference which you could rely on and use whenever you need to. I'm going to focus as a general overview. Thanks. We could move to the next slide. I've been asked to look at those questions. When is an employee regarded as medically incapacitated? In this case, with COVID-19. What are the employer's responsibilities in relation to medical incapacity? Role players, what needs to be there, and what are the responsibilities of those role players? The key issue, obviously, as always, around costs. Who pays for what and when? Then, what are the employee's responsibilities when the employer is managing them for incapacity? We cover that. Then the key issue of sick leave and how it works with incapacity. There's quite a lot more than just that, because every employee, trade union, employer, and medical practitioner supporting their patient needs to understand how, or rather where the resources are to assist an employee who's ill or sick or disabled, such as with COVID-19 sequelae, to have an income while they get better, rehabilitate, and can return to work. So I covered that. Then this issue of medical boarding. There's confusion between medical boarding, disability income benefits, COID benefits, and all the others. We cover all that too. Thank you. So on the next slide, we take a look at what are the actual impairments and disabilities that result from long COVID. To move the slide on if you can, please. Yeah, you can move on to that. Those are the medical references which I've used. Now I've looked at two very current ones. Ziad Al-Ali, he was talking about, he's from St. Louis Healthcare System, clinical epidemiologist at Washington University in St. Louis. I only focus on what he talks about as post-COVID sequelae. He talks about brain fog, you can see that. But more crucially, there are what he says, that COVID leads to an array of problems, including headaches, seizures, strokes, sleep problems, and tingling and paralysis of the nerves, and then crucially, mental health disorders. We know it did because if you were reading the sadnesses of medical reporting during COVID, the suicide rates did go up around the world. And so clearly there's a link with mental health disorders such as anxiety, depression, psychosis, perhaps PTSD, and others as well. But then the doctor talks about significant deficits in memory and executive task performance. He says that mild and resolved COVID showed a cognitive decline of three IQ points. Unresolved persistence symptoms had a 6-point loss in IQ and 9-point in people with intensive care. Now, that's serious stuff because it goes directly to the performance of a job. And for medical practitioners, employees, trade unions, and employers, it goes to the right, the crucial and central right to reasonable accommodation of a person whose brain has been neurologically damaged by COVID-19. And then the last conclusion, the reinfection of the virus contributed an additional 2 points of loss in IQ. So you can get up to 9-point loss in IQ, and that's catastrophically serious. So to the next slide, there was a research that he was talking about. That was reliable research based, of course, on 141,000 participants. They found poor memory and difficulty thinking or concentrating. Now this goes to cognition, conation, and affect, probably, in the performance of any job, which is why law, unfortunately, at this time, hasn't kept up with all this. I need to say, for the NEDLAC people who are here, I would ask you to recall that the Code of Good Practice on Disability, which, as they will know, is a schedule to the Labour Relations Act, it was passed, enacted in 1995. And crucially and importantly, has never, ever been amended since 95. What that means is that relying on that code to try and deal with the complexities of long-term COVID or anything else, in terms of disability and incapacity, it's no longer possible. For employers, it's dangerous to rely on the Code of Good Practice dismissal because it's now 28 years old and no longer states the law. So a point we can make is that COVID-19 drew attention to the failure of law to keep up with medical science and the realities of fair labor practices in relation to incapacity and disability workers. The New England Journal of Medicine article of February 29th, 2004, just last month, talks about all of those consequences which are medical and not legal. So I'll be exiting my lane and moving into fields that I'm not qualified to comment on. But that was the findings. But the implications for law of those medical findings are what obligations do employers, employees, trade unions, and medical practitioners, and occupational therapists, and physical therapists, and occupational social workers and psychologists and specialists all have in law, given the COVID sequelae that these two up-to-date reports are talking about. Right, we can move on. First question I have to deal with is, when is an employee regarded as medically incapacitated with COVID-19? Now, there are two answers to that, which begins the understanding of the complexity of the field, because there's an answer under the Labour Relations Act in those 28-year-old, no longer reliable Code of Good Practice dismissal incapacity provisions, But there's also another answer in the Employment Equity Act if the person is disabled. Now, who distinguishes between whether the person is disabled or incapacitated? And that's not the employer, not human resources, not industrial relations, but a medical practitioner properly qualified in the field. And remember, working out whether the person is disabled or incapacitated is partly, as you would, if you're medically qualified, already know, partly a medical question and partly a functional capacity question. So for a medical practitioner here today, if you as a medical practitioner qualified to diagnose, of course, are uncertain as to whether that diagnosis in that person, in that job, in that working environment at that time, you are uncertain as to whether they are disabled or incapacitated. What do? You call for the assistance of an occupational therapist, ideally, if possible, with a postgraduate qualification in vocational rehabilitation. So between the two of you, you would write a report separately or jointly to the employer around two things: whether the person is disabled under the Employment Equity Act or incapacitated under the Labour Relations Act, and then secondly, what reasonable accommodations they need. Right, and to do all that and to describe for the employers and trade unions and employees what these duties are, depending on whether the person is incapacitated or disabled, we move on to the next slide. Now, under the Labour Relations Act, the LRA, it published in 1995, as I mentioned, a Code of Good Practice dismissal. Schedule 8 to the Labour Relations Act, it provides for dismissal in appropriate circumstances. NEDLAC produced that code in 1995 or thereabouts, and it's also, I would respectfully submit, NEDLAC's not obligation, but need to consider whether the current dismissal code, section 10.1 to 4 and section 10.2, do correctly now state the law 29 years later. It's my respectful view that it no longer does, and that very fact is a risk to everybody. And I would suggest that NEDLAC might like to consider relooking at that, the code on incapacity dismissal, because quite clearly, following COVID-19 and the catastrophe and harm that was caused, that code no longer states the law, as you will see from the rest of these slides. So LRA section 2033 says that any person interpreting or applying the Labour Relations Act must take into account any relevant code of good practice. And the problem there is that code of good practice dismissal, incapacity, and ill health no longer states the law. But section 10.1 to 4 and section 11 must be followed, even though they no longer state the law. And I will, in the next few slides, explain what the law says, even though the law has been superseded over the last 28 years. Right, to the next slide. The code says incapacity on the grounds of ill health or injury may be temporary or permanent, and of course that will hold true even in any amended code. And it's a key decision which needs to be taken, whether that incapacity or disability is temporary or permanent. And going back to COVID-19, sequelae, long-term COVID, the point is that if you contracted COVID and the catastrophic consequences of it, let's say 3 years ago, 2 years ago, and you still have them, it is conceivable that your medical practitioner will reach the conclusion that the brain injury you have to your cognition as a result of the infection to the cognition or cognitive components of the brain will by now be permanent. Then to the next slide. The code then says Oh, yeah. If the employee is temporarily unable to work, which in long-term COVID by now wouldn't be the case, the employer should investigate the extent of the incapacity. That's, of course, where medical practitioners, occupational medical practitioners, sometimes specialists, certainly occupational therapists will come into play to investigate the extent. And then, crucially, absolutely vitally, if the employee is likely to be absent for a time that is unreasonably long, and in COVID that in many cases turned out to be the case, the employer is required to investigate all the possible alternatives short of dismissal. And that means obviously what it says, all the possible alternatives short of dismissal. And the case law of the labor court says that the possible alternatives obviously increase with the size of the employer. A smaller employer, certainly there'll be few, but in larger employers, there'll be many more. That was said in the seminally important case by Justice Pillay of Standard Bank versus CCMA, Myhill and Ferreira, which we'll get to a little bit later. So to the next slide, that's on temporary incapacity. The employer, assisted by the union and the medical practitioner, and the OT must consider relevant factors, which are the nature of the job. So, of course, a job description will be needed there. Sometimes if there isn't a job description, one devises or creates one by interviewing the employee to establish what they actually do. You would look at the period of the absence, and that is a function of three things: the past period of the absence, the present period of the absence, and the projected future period of the absence. You then look at the seriousness of the illness. That would be where a medical practitioner, GP, or specialist comes in to get reports about how serious the illness is. And that's a function of also the period of the absence and the diagnosis. And you can take a look at DSM-5 or ICD-11 to take a look at the projected future anticipated recovery period in relation to that illness. Then this is important, the possibility of securing a temporary replacement for the ill or injured employee. It's over here that for employers in the litigation I do, things start to go wrong. Many employers think that because the person is unable to do their job now, that justifies a dismissal. And of course, the Code of Good Practice itself says that it doesn't, and there's many cases of the Labour Appeal Court and the Labour Court and the CCMA and the bargaining councils, which all say that where a person has the possibility or prospect of returning to work when they're recovered, then you put in a temporary replacement for the ill or injured employee. That raises the next point. Most lawyers who do incapacity hearings or incapacity investigations rather for employers don't really know what the expected duration of an impairment is. They have no clue and they don't ask the medical practitioner for that information. They will recommend dismissal without often considering when the employee's likely return to work will be. And over that period, a temporary replacement for the employee. Okay, moving to the next slide. This is now if the employee is concluded not to be incapacitated, but to be much more seriously impaired, to be disabled. And this is where there's this parting of the ways. If the person is incapacitated, the Labour Relations Act will apply. If the person isn't incapacitated because they're more seriously impaired, they would be a person with a disability, in which case a different act will apply. That is called the Employment Equity Act. That's the Code of Good Practice that we wrote for the Department of Labour in 2004. It's often missed by employers and chairpersons of incapacity inquiries that If the person is disabled, the incapacity provisions don't apply. The disability provisions of the Employment Equity Act do. Now, that's a detailed inquiry which is usually done by medical practitioners following this sequence of steps that I've put on this slide here. You understand that the medical practitioner will, and the occupational medical practitioner ideally supports the employer to identify what form of disability is. Is it physical? Is it mental? But crucially, is it long-term or recurring, or is it progressive? Because if it's any of those three, and all of these other conditions are satisfied, the person will be disabled. The key one is whether it substantially limits. And going back to the focus of my presentation today, long-term COVID, with cognitive declines as a result of neurological injury, it would clearly be substantially limiting. There are certain controllable and correctable impairments that we excluded from the definition of disability, and also it becomes necessary to assess if the impairment is substantially limiting. Certain impairments are excluded for public policy reasons, and if all those conditions are satisfied that you see on the slide, the person will be disabled under the Employment Equity Act and not incapacitated under the Labour Relations Act. What does that mean? What are the primary impacts of that distinction, that the person is now disabled under the EEA and not incapacitated under the LRA? So the next slide then, the implications of that is the employer responsibilities. Let's move on to under the Labour Relations Act. If you are incapacitated, how do the employer's responsibilities look there? You look at the nature of the job and all of those I've mentioned. And if you have concluded that the person is absolutely not disabled, but incapacitated temporarily under the Labour Relations Act, there's an algorithm which I've prepared for you in the next slide, which is that. If the person is temporarily incapacitated for their own occupation, you must investigate the extent in the way I've suggested earlier on. You look at the degree. Is the person able to only not undertake parts of their job or all of their job? And then you consider the relevance of the cause. By that I mean, did the person incur their impairment in a work-related context? And there, of course, for the ones who know these things, we're talking about the Compensation for Occupational Injuries and Diseases Act. Because as you know, if a person has incurred their injury or their disease in the course of their employment, then COIDA will apply. We're going to get to that a little bit later. But how the importance of COIDA at this point in relation to long-term COVID sequelae is that if your sequelae from COVID was brain injury to cognition as a result of neurological damage, COIDA would apply because that would, of course, be an injury to the brain. But, and this is crucial, please, to recall as you go along, if the consequence of your COVID infection was not brain injury through neurological damage, but mental illness, then, as you probably will know, COIDA does not apply because COIDA presently excludes mental illness, whether it's work-related or not, as a compensable workplace disease. The only one that COIDA does cover is PTSD. And that is only as a result of an Eastern Cape High Court decision to do with a journalist who incurred PTSD as a journalist working for a newspaper as a result of the things he saw in the violence in civil society. So if your patient let's say with psychosis or um, general anxiety disorder, serious, or major depression, or obsessive compulsive disorder as a result of COVID-19 contracted in the workplace, then they won't have a claim because COIDA excludes them. That, of course, for the NEDLAC people here is something to consider, I think, desperately seriously, because how can it be that physical injury and PTSD are covered, but all other mental illnesses are not, given the rate of suicide we did have during the COVID period, because all of those would also have not been compensated to the dependents of the person who ended their lives by suicide due to mental illness incurred as a result of work-related COVID.
Peter, apologies, sorry for interrupting you. There's been some comments where, in essence, I guess we may have to ask you just to speak up slightly higher. Some people's volume is at 100% and they have difficulty hearing you. Thanks.
Okay, let me make an adjustment. I'm just using my computer microphone. All right, so I'll talk a little louder. Is that a bit better?
Great, thanks. Please proceed.
Okay, sure. So the specific consideration is whether the illness or injury was work-related, particularly in COVID-19, for the reasons I've given. Now there's the bifurcated split between whether the absence period is or is not unreasonably long, and we go to the next slide for that. Whether the absence period is or is not unreasonably long depends upon two things: the employer's attitude to it, and secondly, how long the absence is likely to last going forward. If it's not unreasonably long, you would then go down the sequence of choices on the left-hand side there, which is sick leave, managing the effects of the absence, the incapacity would resolve, and the employee returns to work. Never forget, please, that an employee who's incapacitated does have a right to return to work. And that arises from case law, and it also arises from the new convention which has been ratified by South Africa, which the Law Reform Commission is now working on. I'm a member of that advisory group, which is talking about how to amend the law to ensure that a disabled employee with an incapacity or disability has a right to return to work when they're better. On the other hand, on the right-hand side of the slide, if the period is unreasonably long, then there's got to be an investigation of all the possible alternatives short of dismissal, as you've seen, and we've discussed the factors there, the nature of the job, the period of the absence, the seriousness of the illness, and the ability to get a temporary replacement for the employee. And then there's another split there. If there are alternatives and they are identified and they are successful, the employee stays on disability until they get better and return to work. If, however, on the other side, the right-hand side of the bottom of the slide, if it's not identified or not successful, this is where the concepts of ill health retirement, a disability benefit, and a retrenchment payment would come into play, which we're going to discuss extensively a little later, and then also the possibility of termination of it on the grounds of incapacity in the form of ill health, if perhaps there is no ill health retirement benefit or insured disability benefit or retrenchment payment. There's the algorithm, and it's designed to assist you to apply, if necessary, to try and deal with the fact that the law is 29 years old and no longer correctly states the law. So then moving on to the next slide, there is also the possibility of permanent incapacity. And again, it's not the employer's decision ever to decide whether the incapacity is permanent. It is the decision of medical practitioners, who are the only people qualified to do that, to determine permanence or temporary nature of incapacity. It's the employer's duty and interest and right, of course, to determine what to do once the employer has the medical practitioners have reached the conclusion as to whether it's temporary or permanent. Now, this is crucial. If the medical practitioners determine it to be permanent, permanent does not. Right? I cannot emphasize this enough because employers get the cognitive understanding of the word permanent. They think it means that the employee is permanently unable to do their job, which of course is not so. It means that the incapacity is permanent. To stop and just draw a distinction between the two. When I'm asked to give expert evidence in these incapacity dismissal cases, the chairperson of the inquiry reaches the conclusion that because the impairment is permanent, that means the incapacity is permanent. Of course, medical practitioners know that it isn't. Many people with many permanent incapacities are able to do their job perfectly with effective, reasonable accommodation. So that's the point in those next 3 bullet points on that slide. Even if the impairment is permanent, the question is then, guided by the medical practitioners, occupational medical practitioners and OTs, is there a possibility of securing alternative employment? And is there a possibility of adapting the duties or the work circumstances of the employee? And some of those are entirely within the scope of practice of an occupational medical practitioner, medical specialist, and GP to do. Where there's doubt about that, then you would hire an occupational medical practitioner to determine that in order to do what? To accommodate the permanent disability of the employee. So you see the difference. A permanent incapacity may not and often does not mean permanent inability to do the job. It's a crucial distinction which many lawyers, advocates, HR practitioners, IR practitioners who do incapacity investigations miss. That permanent incapacity doesn't mean permanent inability to do the job because of the right to reasonable accommodation of disability. So the algorithm for that on the next slide looks like that. You go through all of those. The first part and the top half of the slide are the same, but the bottom one, the bottom half is not. To accommodate the employee's disability. Now we're going to talk about the right to reasonable accommodation in the next few slides, because you do that by looking for alternative employment, by adapting duties or work circumstances. Either the specialist does it if they can. There's a famous case in the Labour Appeal Court of LUMSA versus a motor manufacturer, where the specialist went so far as to say for the individual whose hands would swell up when they couldn't work, the specialist decided that he, I think rightly, could make a decision about alternative employment and adapting duties. Even the specialist mentioned the alternative job and that his duties could be adapted. It's a Labour Court case, you'll see it there. And even the judges, the 3 judges of the Labour Appeal Court mentioned what the specialist said. All right, so the key here is to accommodate the employee's disability. Now we must talk about the right to reasonable accommodation. On the next slide, you'll see what that's all about. I cannot impress upon you enough the importance of this concept. It's a concept and a right and a principle. It's called reasonable accommodation. Every medical report that a medical practitioner or OT writes, or PT, or psychiatric social worker, or IR manager, or HR manager needs to write.
Apologies, Peter. Apologies for my interruption. There's indications in the chat that the audio has gone down again. Thanks.
Okay, let me sort that out. I must talk a little louder. All right. This is the key and most important point probably in all labor law for people with disabilities. the right to reasonable accommodation. It's a principle which is there to enable people with disabilities to have equal opportunity employment with other people who are not disabled. So that makes it a principle. It's also a right, because it's now a right, as you've seen in the Labour Relations Act, but it's also a right in the Employment Equity Act. And it's been confirmed to be a right by the Constitutional Court. Please, whenever you write a report, whether you're an employer or a medical practitioner, even as a patient or a trade union or NEDLAC, or even the Ministry of Labour and Employment, this right must be incorporated into everything. Because by not affording this right, it is automatically unfair discrimination on the prohibited ground of disability. Why is this? Because the unanimous court in MEC for Education KZN versus Pele, Martin, Knight versus Pillay, the governing body foundation of the Natal Tamil Vedic Society Trust, said that it is necessary to consider the concept and the idea of reasonable accommodation. So there's the Constitutional Court talking about reasonable accommodation being a concept and an idea. But crucially, and even more importantly, this was the first time that disability law was recognized to be a separate field of law within labor law. Now, for people like us who write disability law for government and specialize in consulting in it and trying to promote awareness of this field and getting the law changed to reflect it, is that disability law is a separate field of labor law. And the key central component and element of disability law is reasonable accommodation. Let's see what the courts have said about the right to reasonable accommodation. I'm just going to adjust this thing I'm working on here. Next slide expands upon this point even more. In the Constitutional Court, the highest court in the land, all other law must follow any one of its decisions. The Constitutional Court says it requires that reasonable accommodation be made for people with disabilities. Now, why is that? And this is the key to it all. Disabled people are often unable to access or participate in public or private life because the means to do so are designed for able-bodied people. And the result is that disabled people can, without positive action, easily be pushed to the margins of society. Now, that's exactly, of course, what happens unless reasonable accommodation is examined and considered by medical practitioners in their reports, by OTs in their reports, by psychiatric social workers, by safety and health professionals in safety considerations, and by employers and IR and HR. Because, and this is the key, this is why reasonable accommodation is so serious. It is the failure to make reasonable accommodation, to fine-tune society, and of course also employers, so that its structures and assumptions, structures of course are policies, procedures on jobs, and assumptions, that is about people with disabilities and their ability, do not result in relegation and banishment of people with disabilities from participation, which results in discrimination against them. Now, just to stop there, if reasonable accommodation is not specifically raised and specifically considered by any medical practitioner, HR, IR, safety practitioner, trade union, that will be unfair discrimination on the grounds of disability. It really is as serious as that. So please, 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 even though the Code of Good Practice doesn't mention it, but when it gets amended, I guess it will, it is vital, absolutely essential to consider reasonable accommodation. Not doing so has catastrophic consequences. And what are these consequences? If the consequence is unfair dismissal on the grounds of disability, that involves 24 months' salary to the disabled person who was unfairly dismissed. In simple, unfair discrimination on the grounds of disability, it could be more or even less. There's the famous case of Smith versus Kit Kat wholesalers, where a chap, he unfortunately decided to end his own life with a rifle. He severely damaged himself. He was brought back to fine functioning and the ability to work by caring medical practitioners and specialists. When he wanted to return to work, the employer decided to decline to let him do that. Why? And you need to consider this, because the employer found him to be cosmetically unacceptable to customers. These things can have catastrophic consequences, not only for people who reach those conclusions, but also for the disabled person. The judge, Snyman, Labour Court Gauteng, awarded 24 months for that. Getting it wrong in this field has catastrophic consequences. COVID-19 and the sequelae now for people with disabilities brings disability law, incapacity law, and reasonable accommodation to where it should be, higher, far higher on the agenda of employers. And COVID-19 has done that. And I simply ask you, please, to take all this seriously, because the consequences of not doing so are catastrophic. Next slide, please. Now, to re-emphasize the point that I just made, taking reasonable steps to accommodate diversity and, of course, disability is a factor for the determining of the fairness of discrimination. From this, it is clear that reasonable accommodation will always be an important factor in the determination of the fairness of discrimination. It can't be more clearly put. You have to consider reasonable accommodation, because without doing so, you cannot determine whether the dismissal on the grounds of incapacity or disability was fair. It really is as simple as that. And for employers, please advise and alert the individuals and independent contractors you use to do these incapacity investigations on your behalf in relation to people living with long-term COVID or any other disability. If they do not do that, you, the employer, will be exposed to claims of unfair discrimination through no fault of your own. It will have been through the negligence of the chairperson of the incapacity inquiry. Please make sure that your chairpersons of incapacity inquiries know what they're doing and understand this law, because they will expose you to the risk of discrimination claims. Moving on then. The Labour Appeal Court put it differently. In the case of independent municipal and allied trade union, on behalf of Stradom, the employee versus Witzenberg municipality, here the Labour Appeal Court said something even more important too. They refer to a book written by academics. You can see it there, where the academics said the duty of reasonable accommodation by employers is not confined to the Employment Equity Act. I so far have been talking about it in the context of the Employment Equity Act. But no, the Labour Appeal Court says the duty of reasonable accommodation is the duty that is implied in the concept of unfair discrimination in the general sense. That means outside of labour law itself. So what does that mean? And that's the third bullet point there. The duty of reasonable accommodation of employees is one of the judicial, that's judges, and legislative, that's parliament, tools for realizing substantive equality, in this case for people with disabilities. That's how important reasonable accommodation actually is. It cannot be overemphasized. So please, if you're an employer, please take this seriously. You will avoid unfair discrimination disputes, and you will promote fair labor practices for disabled employees. If you are HR, always consider it. If you are IR, always consider it. If you are an employee listening to this, always request it. If you are a medical practitioner or health professional, writing reports in relation to diagnostics, duration, severity, permanence, temporary, all of the rest, please always mention that, because if you don't, it's going to have catastrophic consequences for the employee, in this case, living with COVID sequelae. Then in the labor court as well, on the next slide, it's also been said, Standard Bank versus CCMA, Myhill and Ferreira was an important case. The judge, Justice Pillay, was talking about how discrimination arises because of difference. One of the cognitive failures of human beings is that when they confront something they don't understand, what do they do? They don't take further steps to investigate it. Rather, we dismiss what we don't understand, or we don't take further steps to investigate. That was the point the judge was making there. And she says that living with a disability may be hard enough without having the additional burden of conforming to mainstream society. So that's the duty of a medical practitioner, to help employers help themselves, to find reasonable accommodations which will assist the employer and guide the employer to reasonably accommodate people they don't understand. And in this case, people living with cognitive impairments and mental illnesses that result from long-term COVID. And she says, after all, the essence of true equality is the accommodation of difference. It cannot be more strongly and more effectively put than that. We're a country in which we respect the diversity of everyone and the difference that everyone brings to society and employment. And everyone needs to be accommodated to respect their difference and their ability and opportunity to participate. Right. Thank you. Then to the next slide. My other thing I was asked to deal with was about payment in relation to all the sequelae from COVID-19, which of course apply equally also to people living with other diseases and injuries. Let's go through them. We're going to look at the compensation commissioner, insurer, medical scheme, the state itself, the employer, and the employee. Let's look briefly at those. They're subjects in themselves, but I want to alert you to them so that you understand what you can do for your patient and what a patient can do for themselves, and how an employer could help an employee with post-COVID injuries and mental diseases. Okay, next slide. First, the compensation commissioner. Many of you will know that the compensation commissioner is responsible for the payment of work-related admitted claims. So there are two things there. There must be work-related injuries or diseases, and the commissioner must admit them. Now, the COVID-19 infection must itself have been found to be a work-related infection. You've seen Richard Spoor, the attorney's work on pneumoconiosis and all of those cases in relation to work-related mining injuries. The same really, the principles there apply to COVID-19 infection in the workplace, which of course is difficult. It might have been incurred elsewhere, but this is COVID-19 in the workplace. So if it was incurred in the workplace, the neurological impairment, the brain injury, neurological brain injury, must have been found to be caused by COVID-19. Crucially and importantly, the COVID-19 infection that resulted in mental illness would not be covered by COVID, no, by COIDA, because it doesn't cover mental illness. The employer then pays us for cover for its employees every year, and the compensation commissioner will pay the costs of medical care, an income benefit for the duration of the employee's inability to work, a pension benefit if they're permanently unable to work, and a dependence benefit if they die. Now, for those who've been watching the amendments to the COVID legislation, you will have seen, and the medical practitioners I give lectures to will by now know, that there's been amendments to COIDA to create the right to return to work when the person has recovered. Crucial development, absolutely massive implications for everybody. It means that employers will have to take back an employee who has recovered to the job that they had or to a different job. Please, please, please take a look at the amendments to COIDA. Recently published, not yet enacted, but look for the appointment of a disability coordinator that COIDA will appoint. And there's going to be a disability manager that the employer must appoint in order to make the return to work process work, which of course is another reason why the Code of Practice dismissal, section 10 and 11, will also become immediately outdated the moment those COIDA recommendations come into place. Okay, next slide. The insurer.
Sorry, Peter, just 5 minutes before the Q&A session. Thanks.
Okay, I must move. It's a complicated field. I apologize for this. Look at the insurance side of it. The employer must apply for the disability benefit for the employer. If the insurer admits the claim on behalf of the employee, the benefit will pay 75% of the disabled employee's salary. Employers have a duty to apply for this benefit before dismissal. That's also been left out of the Code of Good Practice dismissal. If it's a lump sum benefit, the lump sum benefit will pay 1 times, 1.5 times, 2 times the employee's salary if the person's permanently unable to work. Right, next slide, please. The medical scheme, it's a voluntary scheme. There's no obligation until NHI comes in. There's no compulsory medical scheme. The employee pays for medical scheme. Sometimes the employer subsidizes it. The membership can be either under a group scheme policy taken out by employer or an individual policy the employee takes. Remember, please, on the next slide, that it's crucial to remember for medical scheme members that, on the next slide, please, there's this issue of medical claims versus COIDA claims. I won't get into them, but I leave that with you as a ready reference. What a medical scheme member must do if they've also got a COIDA claim. It's quite technical, but it's important to know because it's about financial administration of benefits. To the next slide, please. The state is the provider. Many employees don't know that they can get cover from the state if there is no medical scheme and there is no COIDA claim. You can go and get cover from the state. A medical practitioner, however, isn't obliged to accept a COIDA claim, but the employee should be referred for state care if there is no other care for them. Next slide is the employer. The employer pays without the employee for COIDA benefits. Remember, please, this is important. It's often forgotten by everybody. Once a claim is, employers often don't put in claims because it's going to mess up their record for no injury on duty claims. The unfair labor practice claims I get involved in when employers refuse to submit claims because it's going to mess up their record. But it's also important to please remember that the employer must pay the first 3 months' salary of a person who's submitted a COIDA claim. Often not known, section 34(1), I think it is, the employer pays the first 3 months of and continues paying the employee's salary at 75% until the claim is assessed by the compensation commissioner, vital to help the employee with the salary if they are unable to work. Next slide, please. Now, the employee responsibility is not a one-way street where employers have duties and employees don't. The employee also has duties, and non-fulfillment of these duties is serious because the employee must participate in the process that the employer has a duty to fulfill. Here they are on the next slide. The employee must, when unable to work, request a medical certificate, submit a medical certificate, and notify the employer to apply for the disability benefit, because many employers don't apply for the disability benefit for the employee, and the employee can lose hundreds of thousands of rands because the employer doesn't apply for the benefit because the code of good practice doesn't state that it should because it's 25 years old. And when receiving a disability benefit, the employee must fulfill the insurer and the fund's instructions and must submit medical reports, and they must not frustrate the employer's legitimate need to determine continued eligibility, and they mustn't subvert the purpose of the benefit the employer is trying to provide and not provide if it's not due. Next slide. The employee must follow incapacity inquiries, and when they have recovered, they must actively participate in the return to work process, and they must follow medical recommendations, and they must attend job tryouts. Okay, next slide. Now, this is vital, but I'm going to leave it as a slide for you to consider and talk very briefly through it. The key thing is how to help an employee with a disability to keep having income to pay their financial liabilities and support their families and keep their kids at school and have money for food while they're incapacitated. Please look at this slide. It works like this. First, apply to the employer for sick leave until available sick leave is ended. Then, under the employer's certificates of service, apply for extended sick leave if it's available. Then IODs, apply for quota benefits and get for the first 3 months' salary from the employer. Then apply for UIF, the sickness benefit, rather the illness benefit from the UIF. It pays a sickness benefit for a number of months. All this is left out of the code of good practice dismissal. And then crucially, if they're insured benefits, apply for temporary disability. The employer must do so on behalf of the employee. Next slide. If it's permanent disability, you must apply for a capped disc benefit. The employer must do that on behalf of the employee. Please, medical practitioners, would you ensure that that is done on behalf of your patients? If the employer's got private disability policy cover for mortgage protection, for credit life, if they have a car or if they have a lounge suite or a flat screen TV, always apply for private disability cover. And if they are ill health, if they are members of a retirement fund, always apply for ill health early retirement from the fund. The employee does it themselves. I'm getting to the end now. Next slide, please.
Peter,
Yeah,
could we pause here?
yeah.
And this is with two quick one announcement and one recommendation. For all of the attendees, the full video recording and PowerPoint presentation will be made available to you after the webinar. We'll send you an email with a link and you can look at it again. However, we didn't cover all of the slides that Peter has prepared, and there is a suggestion and a recommendation from my side that we do a follow-up session. And one of the suggestions is that the follow-up session could be a question on COIDA amendments and occupational disease plans and benefits where you are now. So I'm not sure how you feel about that, Peter. If you could consider it in the meantime, I'm going to again encourage colleagues who have any questions to type that in the Q&A box. That's the question and answer box. And if we do find ourselves, well, Carla Hector Slutz is supportive of the idea of a follow-up session. Carla says, great idea, please follow-up. So yeah, Peter, there seems to be some support from the attendees for a follow-up session, and we can perhaps chat to you offline about that details. Okay, this is an amazing session thus far, info overload, but brilliant. And I think that's also in support of a follow-up session. So I'm going to hand over immediately, colleagues, after reminding you that we will be having the video recording as well as the full power presentation on our website and on our YouTube channel, and we'll send the links to you. I'm going to hand over to our QO session chair, and that's Dr. Graham Chin. Graham, over to you, please.
Yeah, thanks, Ashraf. I mean, judging from the audience and the participants, this is a very important topic. And there are some questions, and I think it's only fair that we cover those questions that were posted, because I think they're very relevant to this topic. And then I think we can look at perhaps a follow-up session. I just want to quickly go through, Peter, if I can go through the questions with you from the audience. Question number one was, good day, how relevant is medical incapacity related to COVID at this current time? If you can just give us a response.
Sure. The answer really lies in what are the consequences of COVID in terms of functional incapacity. And as I mentioned in the first few slides, that can be profound mental illness that impacts working from a cognitive or affective point of view. And secondly, if there's been neurological damage to the brain, which also affects functional performance due to cognition or the ability in relation to cognition and conation, that will be a functional incapacity, which needs to be reasonably accommodated. And if it's so serious that the person can't do their job, then a COIDA claim would have to be made, or an insured benefit claim would have to be made.
Okay. Peter, second question. When you did your flow diagram, what is considered unreasonably long? And I think that was in relation to your temporary incapacity slide, if I'm not mistaken, one of the flow charts. The question is, what is considered unreasonably long?
Yes, indeed. There are two halves, or rather two parts to that question. An employer's decision is whether it is unreasonably long. That's the employer's right and their ability to reach that conclusion. But you can only reach that conclusion once you have enough information. And the first piece of information you need is how long before the person is likely to be able to return to work. And when they are able to return to work, will they be able to do all of their job or part of their job? And the other part of that is, should I not apply for a disability income benefit from an insurer or a COIDA benefit for temporary total disability until the person is actually better and then they return to work? These are complex issues, and
yeah,
you know, I see one person say, I regret that I couldn't finish, but there are so many issues, and that is a crucial one. There are many others.
Peter, just another one here. The problem we have, and this is obviously broad principles, the problem we have is that an operator job, specialist job, employee becomes incapacitated, obviously an operator. Now the insurance tells the company this individual should go get an admin role, but that is not possible within the company. What to do now?
Nice.
Just sort of broad strokes, Peter.
Yes. What often insurers are doing is to say, yes, this person can't do their job, but they can do another job. But the qualifying criterion for the benefit is that the employee can't do their job. So for an insurer to say the employee can't do their job, but they can do another job, is often a way to avoid paying the benefit, even though the employee does qualify for the benefit.
Okay, so it's really about the employee's own job that one has to look at.
And to
Peter,
do that,
sorry, go ahead.
Sorry, just to compete on that, you do actually have to understand what the qualifying criteria for the benefit, for the insured benefit is. And if you ask the insurer or the broker has to provide it to you. Often a good person to work with is the broker, because the broker has a duty to promote the employee's interests, and they often do that in conjunction with the medical practitioner or the trade union or the employee.
Yeah. Peter, can one's salary be reduced during the process of reasonable accommodation when one does a job of a lower grade? I'm not sure if that's in your space, but maybe something
Yes.
HR, but legally?
No, it is. The objective is to avoid that having to happen. And to avoid that having to happen, there's a concept that you take from occupational therapy. It's called job enrichment, where to avoid that possibility, you enrich the person's job to keep it at you insert new responsibilities into the job to keep the value of the job at the same value the person had before they became disabled. Occupational therapists use the principle of job enrichment for that, to avoid that happening. But if the job can't be enriched, or if the employer is absolutely unwilling to do that, then it's conceivably possible, if a disability income benefit doesn't apply, for the salary to be reduced. But it's usually done over a period of time so that the employee can make adjustments to their personal financial position.
Okay. Is the requirement for reasonable accommodation apply irrespective of whether the disability is work-related or not?
Yes, absolutely.
Good.
It's even stronger where it is work-related, but it applies regardless.
Okay. There's a scenario here. I hurt my back at work performing work duties. I then went back. I then went to see an IOD doctor who sent me for physio. I felt better. Then after the session with physio, but the pain comes back sometimes, especially when I do house chores or intense labor work, including at work. So does this mean I could fall in the category of incapacity?
For the person who's asking that question, would they please take a look by doing an internet search for the case of CCMA versus, no, for Standard Bank versus CCMA, Myhill and Ferreira. That dealt precisely with an employee who had a back injury and the duties of the employer to accommodate it. Many of the questions that the inquirer has will be there. But the other point that arises is when the employer does know that you have a back injury, you may not be instructed to do more work duties which exacerbate or cause a recurrence of the back injury, because that would be a second workplace injury.
Okay. Peter, here's an interesting one. Can an employee face incapacity due to overweight? Employee weighs above 120 kilograms and I have to work and have to work at heights and inside confined space, and therefore, because of their weight, cannot be allowed to do the job and therefore declared permanently unfit.
Nice one. There's a case from the industrial court on exactly that. This was a person who wasn't able to perform their duties because of a mass which was greater than what was required for them to perform their duties. In relation to mass, one is talking about the effect, that is the mass, but there's often causative factors which, if they were addressed, would affect the mass issue. So one has to look into mass as an effect and what was the cause of that, because as you know, in psychiatry and in specialist physician work, the mass as an effect can result from causes which, if they were addressed, would solve the problem. And the key is, in this case, dealing with that, but also helping the employee with a wellness program to assist them to reduce their mass, but dismissal would not be immediately possible, no.
And I think your example, Peter, or your response illustrates how a lot of these disciplines, a wellness program, employee assistance, need to be integrated into your entire incapacity program as well.
Graham, just to stop there, it was going to be in my slide. There's a constitutional right which no one knows about. It's called psychological integrity. Now, if you ask yourself, where does psychological integrity fit into labor law? Short answer, it doesn't. And the way it does is partly in the duty under occupational health and safety to identify mental health risks. But of course, OXA doesn't do that. It focuses only on physical risks. I know one knows that because if you look at all the regulations in OXA, it doesn't mention the duty to look at psychological and psychosocial hazards. It doesn't even impose a duty on employers to identify in their interactions with each other, not creating psychological risks through bullying. This is another thing, it was in my last few slides, that until OXO protects employees from psychological and psychosocial hazards and risks, more people will have nervous breakdowns and suicides will always be up, which is another reason why the Code of Good Practice dismissal must be amended as fast as possible by NEDLAC. There's catastrophic failures.
Yeah, agreed, Peter. And then maybe just to end off, there was one question around follow up on your KitKat employee. The question is, what happened to the KitKat employee post judgment? Was he placed in another section? I think we can just end with that one.
The psychiatrist in that case recommended it. In the evidence in the court case, the judge said, I have no difficulty looking at him and I have no difficulty hearing what he says, because that's what the judge said. But the employee didn't want to go back because he felt that the environment was so toxic. He was awarded $1.25 million because of the humiliation and degradation that he suffered as a result of the attitude by the employer to his facial disfigurement and his difficulty speaking, which the judge in the court had no difficulty with at all.
Peter, thank you for indulging us, and thank you for all the participants for sort of holding out just so that we could get through all the questions. Thank you, Peter. I think we've answered all of them. Ashraf, back to you.
Yes, thank you very much, Graham, and thank you very much, Peter Strassheim, attorney, and you can see that, trainer, etc., lecturer, and so on, and he's been quite active in this field and related areas. So there's been quite a strong follow-up, Peter, on the webinar chat box for, or rather support for a follow-up. And as you've indicated, that some of the aspects that you were still going to deal with in the remaining slides was also related to some of the questions that was raised. So I think we will definitely engage with you offline about a potential follow-up, if that's okay with you. Your case has also brought up a reminder of a nurse at Tygerberg Hospital who had acquired latex allergy and was not reasonably accommodated, and the CCMA, after dismissal, reinstated her to another facility, which was, I think, latex neutral or latex friendly in the employee sense. Okay, that was amazing. There's been lots of positive comments in the chat box about this being a very interesting session. Morena Linso, for example, the medical incapacity is complex. It needs more time. Please extend the future sessions to a longer time. Okay, so let me then conclude on some of the admin. We have still over 500 people. I mean, at one stage it was 530 that's still online. And thank you for your patience and indulgence for allowing us more time. A quick reminder, an application has been made for the CPD point, one CPD point for the hour, and we are waiting the final approval of that. And once it's approved, we will be sending out the link and the password for the online CPD test with the multiple choice questions. And then you can then secure through that process your one CPD point. Another reminder, our video recording as well as the PowerPoint presentation, all the slides will be made available on our website and our YouTube channel, and we will send out those links to you as well. At this point, I need to say thank you very much, so much. It was one of the most interesting webinars I've attended, very detailed, very practical, and there's been a great level of interest in this. And that's attorney Peter Strassheim. Peter, thank you very much for taking the time to prepare and to present. And we hope that you'll be agreeable to the recommendation and the support from the attendees for a follow-up session. Thanks to you, Peter. Okay, and then finally also thanks to the team, the Zoom team, and in particular the colleagues in the IT department, and that is Tabani Zwane, our supervisor there, and Sibosiso Mabena, who also joined us today in our session. With that, we close the session. Thank you very much, everybody. We look forward to seeing you on our next webinar. Goodbye.